London has been a close partner in India's journey of developing and establishing the insolvency and the bankruptcy code, right from the days when the bankruptcy and legislative reform committee was constituted. Uh, and I think, given the present pandemic and which has resulted in a unique set of challenges for insolvency and bankruptcy globally, we thought it was only right for the Centre of Policy as well as the City of London to come together and organize a series of discussions on relevant topics. And today is our inaugural session. Very briefly, I'll just go through today's agenda in terms of the program. We basically have 3 sessions. The first session is to hear from our keynote speakers. The second session will be the panel discussion, which will be chaired by Dr. Susan Thomas, who was a member of the BLRC, and our distinguished panelists who are joining us from India, UK, and the US. Susan will, of course, introduce you to them at length when she begins the panel discussion. The final session will be a Q&A where we'll host questions from the audience. Following the session, the City of London and the Centre of Insolvency will develop a policy note to be shared with all key stakeholders. May I now invite Alderman Vincent Keaveney for his opening address. Over to you.
To meet again soon in person in London or indeed in Mumbai or Delhi. I know how much we're all looking forward to that moment. May I say on behalf of the City of London Corporation how grateful we are to both the Insolvency and Bankruptcy Board of India and the Centre for Insolvency and Bankruptcy for their support in organising this panel discussion. I'd especially like to thank Mukulita Vijaywargiya, a whole-time member IBBI, for joining the discussion today. Thank you. The City of London has managed a dedicated programme of engagement with India for some years now, facilitated through our representative office in Mumbai. Our priority focus areas are fintech, insurance, reinsurance, green finance, UK-based financial services businesses in India, and of course, Indian firms who want to do business in the UK. Through dialogue and engagement, the 2 key elements, dialogue and engagement between industry and government, we have worked to strengthen those key business links between our 2 countries and to boost trade in financial and professional services. India introduced her landmark Insolvency and Bankruptcy Code, the IBC, in 2016, with a view to encouraging quick and efficient corporate rescue and restructuring. The IBC has introduced some commendable infrastructure, such as dedicated company law tribunals, a dedicated regulator, and strict timelines. The IBC follows a system similar to that of the UK's practitioner-led insolvency procedures, and architecturally has many similarities to the UK Insolvency Act 1986, something I see myself as a practicing financial services lawyer. India also shares a common law system with the UK, a great shared heritage. Seeing these shared experiences, the City of London, indeed all of us on this call today, recognise that there are real opportunities for the UK and India to collaborate on implementing the IBC, whether that's in the implementation and continued development of insolvency law, the development of the insolvency profession itself, or other areas for collaboration, those we'll discuss today. In practical terms, that has meant that the City of London, in association with UK legal and insolvency professionals, sharing best practices and UK case studies with the IBBI in areas such as cross-border insolvency, individual insolvency, and valuations, have been able to contribute to that growing partnership. But across the world today, of course, businesses and governments are contending with the financial caused by COVID-19. One response has been the provision of financial support to businesses by government. Another focus has been insolvency law. with various measures introduced to enable businesses to avoid insolvency proceedings due to what we all hope will be a temporary disruption to our lives. As we will shortly hear, the UK government has introduced new insolvency legislation to help businesses that are struggling from the economic impact of the pandemic. The new Corporate Insolvency and Governance Bill going through Parliament at the moment will create more opportunities to save companies that are in difficulty and to offer better protection from creditors during this difficult period. We have an excellent panel today. Thank you all for participating. That will consider the impact of the pandemic on insolvency and bankruptcy policies and the measures being taken by our respective governments. I certainly am looking forward to hearing that discussion today, and I'm looking forward to the opportunity that this gives us to deepen that important engagement between the UK and India in this area of insolvency and bankruptcy. Thank you all very much for attending. I hope you enjoy today's seminar.
Thank you very much, Vincent. It gives me great pleasure to invite Ms. Mukulita Vijaywargiya, whole-time member from the IBBI, for the keynote address. Ms. Vijaywargiya, please. Do we have Ms. Vijaywargiya online?
She was, I guess she dropped off.
Yeah. Now I am unmuted. सभी भाई बहनों को मेरा yes now I'm audible.
Yes.
सभी भाई बहनों को मेरा नमस्कार. Good afternoon, everybody. My greetings to all the distinguished panelists, learned professionals, and participants of this webinar on hitting a pause in a pandemic, insolvency and bankruptcy policy 2020 and beyond. I thank City of London for its association with the IBBI. This webinar, I wish all the professionals, panelists, and participants a healthy and safe life. Now, this is the first phase of lockdown, unlocking phase 1. COVID-19 has caused industry disruptions. I think volume has been unimaginable. I think it is difficult to assess what kind of and to what extent it has caused disruptions. But no doubt, the disruptions has exerted the pace of insolvency in every sector, maybe individuals, maybe corporates. Everywhere we will find that it has affected individuals as well as corporates both. And we know that this COVID-19, though it has adversely affected the industry sector, but it has given a new slate for writing new legislations, for amending our legislations, to redesign our model of industries, to rework for the, to redesign our work culture for the offices, for the professionals. And certainly this COVID-19, it has not affected India, but it's throughout the globe we find. And actually we can share the experience of other countries where they have taken steps to mitigate the effects, adverse effects of the COVID-19. COVID-19, though it has generated industry disruption on the workforce competency, organizational morale also. On the other side, it has given an opportunity to the new professionals, new entrepreneurs. And I think recently the government has organized a very big package, economic package, and it is a big opportunity to develop innovative practices for managing organization change. And for managing organization, certainly the management curve, respect of the alignment, communication, motivation, adaptability, development, and knowledge sharing. By this, we will be able to navigate the disruption to galvanize the organization towards high value income. I think our Honorable Prime Minister, Mr. Modi ji, has also in its address, I think around when there was complete lockdown on 25th March, in his address, he also talked about 4 objectives to address situation, and that is adaptability, efficiency, inclusivity, and opportunity. This should be kept in mind while redesigning any industry model or while addressing the challenges of COVID-19. We all know that entrepreneurs are very important for the economy, and they should not be the ones to take all the burden of losses. No economy will support any condition which will end up with financial death of the employers and will ensure survival of employees. So keeping that in view, the government has declared a package, and according to which, government has tried to address the situation of COVID-19. And as I told you that it has accelerated the pace of insolvency and the volume of the insolvency of the industries. So on through a government a notified ordinance, it promulgated an ordinance on 5th June 2020 in furtherance to the economic measures announced by the Ministry of Finance to support Indian businesses, and according to which, the cases for the default which are arising during this period, no insolvency application will be filed by any creditor, debtor, or the operational creditor. It's a big relief given to the industry, because now that they have the breathing space that, okay, nobody will file an application against me to push me into liquidation. So two big measures which have been given by the government is, first is the suspension of the application under section 7, 9, and 10. So though nobody can. So be relaxed, have a breathing space, and develop and adapt innovative practices to revive back your company, your production unit, or any CD. Second big relief is that any default which has occurred during this period, in future, nobody will file an application. In future also, it is not that during this time they will not be able to file because there is suspension. No. In future also, they will not be able to file any application or insolvency if the default is occurred during this period. Certainly, this is a very big relief given. I think no country has given such a relief. Only I think in India, government has been very kind to the industry, that it has also mentioned in the ordinance that nobody will file. It may be noted that the special insolvency regime nowadays, it is in, I think it is a special insolvency regime regarding MSMEs. I think shortly, maybe in times to come, it may be notified, it may be announced. But prior to that, to begin with, the government has changed the threshold of default, keeping in view that the MSMEs should not be pushed to liquidation, and that's why the government has changed the threshold of default from 1 lakh to 1 crore. It's a big relief given to, and especially the MSMEs will be availing this opportunity, no doubt. Now, the prohibition on IBC proceedings for defaults during the specific period. Section 10A prohibits filing of the application till the end of the specific period. Maybe this period may be 6 months, maybe this period may be extended to 1 year, no doubt. But because of this approach, you will find that it does take up the possibility of extended disputes on the cause of default. For example, there are other acts, Surface I, there are Liquor Debts Tribunal Act. No doubt, people may approach and get the relief because here there is a prohibition. Certainly, they will go and take relief under those acts. Whosoever will find that I may gain something under this act, other than the IBC, certainly they will do it. The second point is that the reckless behavior of the directors prior to March 25th, 2020, prior to lockdown, which led to a default during the specific period, may be punished under the Companies Act, because directors will not be responsible for any default during this period. But the reckless behavior of the directors they may be punished under the Companies Act as a breach of director's duties. So, though there is a complete prohibition, but there is no provision for approaching under other acts. Now, if we analyze the situation, then we'll find that introduction of the ordinance, giving prohibition, giving suspension, naturally, we will go, industries will go for out-of-court restructuring regime. And I think it's a good thing that the courts will not be burdened even after, if the lockdown is completed or there is a unlocking phase 1 or 2 or 3 and there is a normal situation. So people will be accustomed, the way we are accustomed to live with the mask, to follow social distancing. So certainly people will be having, they will approach out of the court restructuring regime under the prudential framework of a resolution of state of the RBI. I think it was notified on 7th June 2019, and they will adopt that prudential framework of resolution of state assets. They may also go for mediation. They may also go for out of court restructuring and arbitration. So I think that those remedial measures will find means those remedial measures, you will find an increase in those remedial measures instead of IBC, or maybe on times to come, maybe on a regular basis, people will approach or exhaust first the remedy of mediation or arbitration and then come to insolvency. Secondly, where have to rely on the applicable recovery and enforcement other acts, which I have told you. The ordinance places no prohibition on insolvency bankruptcy posting of personal guarantors, because it has mentioned about section 7, 9, 10, which relates to corporates, not to the guarantors. So guarantors have been excluded and the guarantors are free to move. I mean, they can move the application and they can go for it. So, I mean, I think, what should I say, that corporates have been prohibited, but not the personal guarantors. Thirdly, the ability of the companies to file themselves into insolvency under IBC has been prohibited. If a need is felt that the company should be liquidated at the binding, there is a voluntary liquidation process available. So this is prohibited, but you will find that the voluntary liquidation process is also available. Another very crucial question that arises is that there may be a moral hazard, risk of debtor covered by the exclusion undertaking undervalued. So what happens during this time? The debtor may, because the proceedings are suspended, something is prohibited, so debtor will take this opportunity for undertaking undervalued or preferential transactions and dissipating assets of the company to the detriment of the creditors. Here, creditors will need to monitor the debtors more closely to avoid such a situation. So these are the certain impact, the side effects of the suspension, of the prohibition, that the creditors also need to look at it, because during this period, there will be no COC, there will be no insolvency applications. So what will happen? The debtors will adopt these techniques to manage or to revive whatever they like. So here I think creditors have to be more, the banks need to be more vigilant about their activities, what they are doing. And concludely, I will say that this ordinance, which has been promulgated, it seeks to provide adequate breathing space to Indian business hit by the pandemic. Well, there is a small chance of debtors abusing suspension for defaults during the specific period for reasons other than pandemic, given the extent of damage otherwise to the economy, such a chance is minuscule. Now, just I would request the panelists that many legislative amendments have taken place in other countries, whether those can be adopted, can be followed. Practices have been actually to meet the situation of the COVID-19. More important is not the what is the legislation at present or what amendments have been carried out in those legislation. But more important is the practices. Now business people have to evolve innovative practices to redesign their business models, professionals to redesign their work culture. So I think we should focus on that, because without doing that, we will not be able to make this suspension or prohibition successful also. Because government has helped us by doing this, government has helped us. But if we don't evolve best practices, this suspension prohibition is for a limited period. Okay, fine. This default situation, insurance will not be filed in future at any time, fine. But the situation is it's a temporary thing for 6 months or 1 year suspension. So we need to develop best practices, keeping in mind that such disasters, now it is Corona, COVID-19, but many more disasters in many forms may come in. Maybe a cyber, I don't know, because now it's all digital, it is all electronic. We have e-mode meeting, e-mode the way we are having. So there may be many more hazards, not only natural disasters, man-made disasters also. So we should evolve practices which can withstand all weathers, all kinds of scandals, I should say, or all kinds of systems which may happen in future because of similar to COVID-19. Thank you. Thank you very much.
Thank you very much, Dr. Vijaywargiya. And I think you raised a very pertinent point in terms of coming up with innovative solutions, and I'm sure our panelists will debate that. With that, can I now invite Dr. Neeti Shikha, Head of Center for Insolvency, to please address the forum.
Yeah. Thank you, Anita. Thank you, Mukulita ma'am. First of all, let me thank City of London for this wonderful collaboration that they have entered with Center for Insolvency and Bankruptcy. I would like to share that our center is the first to be formed in India to do a focused research in insolvency and bankruptcy. The purpose of this webinars that we are doing with City of London is to find solutions through cross-country learning. COVID-19 pandemic has resulted in shocks in financial system in form of increasing in non-performing loans, insolvency filings, and unnecessary liquidation and asset fire sales. Now, government responses so far has been mix of regulatory forbearance, higher barriers to entry in formal insolvency proceedings, and extension of procedural deadlines. There has been range of responses from suspending the duties of directors to file the insolvency, like in the case of New Zealand, the UK, and Australia, and to provide liquidity measures for distressed businesses. Business debt hibernation is also one form of response that has appeared in the case of New Zealand. Switzerland and Spain and Australia have temporarily suspended insolvency trading norms. That is, directors can continue the business of the companies despite its cash flow and indebtedness situation on account of impact of COVID-19 being low. Germany has adopted a similar approach. However, it is likely that continuing the business and incurring further debt without careful plan to revive the business once the restriction ceases will not protect the directors. Spain has temporarily suspended creditors' right to file insolvency. Australia has not entirely suspended the creditors' right, but like in the case of India, it has increased the statutory demand from 2,000 Australian dollars to 20,000 Australian dollars. Now, all these learnings that we have gathered is from the Friday web series that we started on 24th of April to learn the impact on insolvency laws on various jurisdictions. So far, the center has covered 9 jurisdictions from 16 experts across the globe. Ms. Mukulita ma'am has already covered the India's response quite in detail. Now, two things that we like to mention here is that it is highly unlikely that we can adopt a one-size-fits-all approach in case of policy responses. It is important that India learns from the experiences of other countries, but the Indian response has to be homegrown. The purpose of this webinar is to explore what could be a good fit for India and what could it not. And I'm really happy that through this collaboration with City of London, we are able to start the dialogue. And today we have an esteemed panel with us, which Ms. Thomas would take us through. And Anita, I really thank you for giving the center this opportunity to take this dialogue forward. And I look forward to a very engaging session. Thank you so much.
Thank you so much, Neeti, and we look forward to a very constructive collaboration as well. So with that, may I now invite Dr. Susan Thomas to commence the panel discussion. Susan, over to you.
Thank you, Anita, and thanks to the City of London for having put together this amazing effort. It's actually quite cool because I think that it's been a long time since I've seen so many people on a forum who have been fellow partners in having played a central role in the creation and the making of the IBC. Mukulita was one of the people who was part of the Bankruptcy Law Reforms Committee. And as I look through the panelists, in the order in which I think that we will invite them to give their comments on the topic that Neeti just described, that is, in this moment of pandemic, what is it that we should be thinking about as what should be the legal framework around the bankruptcy and insolvency resolution that we should think about, because we are anticipating so much more often of firm stress that's quite external to the operations and the business models of the firms themselves. For instance, Dr. K.P.Krishnan is pretty much everything that's important in this field. He's a lawyer, he's an economist, and he's a career bureaucrat who has, by the way, just finished with his long and diligent service. Congratulations, Dr. KP. He was, by the way, the first chair and convener of the BLRC, and so has seen the policy in this area from the very start. Bahram Vakil is a founding partner at AZB Partners, And he was, we used to joke that lawyers and economists never get along, but Bahram was a stalwart and a very sound partner in the BLRC, all the way from guiding us, the economists, on the realities of insolvency resolution on the ground in India, and also learning with us the economics of the area while we were designing the law. You think that Angela and Philip being in the UK with and partners at the Penningtons, Manches, Cooper, there will be very little of a linkage to those early days of our learning about the bankruptcy reforms for India and the IBC. But we did meet Philip, who was a very kind and gracious host when we were trying to find out how it is that there were strong points in the UK system that we should take on board, and the kind of lessons that we should learn on their failings when we were designing the law. In our session today, we are hoping to think about how it is that as jurisdictions make changes and tweaks to their insolvency and bankruptcy resolution framework, how is it being taken from the ground? And I think Angela is fantastic to have on this panel because she's got long experience with dealing with financial transactions. And we hope that she will talk to us about how it is that the creditors in the UK and the more global community is dealing with the pandemic and the stresses that have come up. While Philip, I'm hoping, will tell us more about the debtors' response to both the kind of stress that they are facing, as well as the innovations that the bankruptcy system in the UK is evolving in order to help them deal with it a little more efficiently as compared with just shutting up shop and going home. I'm told that Alderman Keaveney is also got lots of experience with in the field of the financial sector and with banks, and hopefully he will also be able to come in and tell us a little bit more about how the UK system is dealing with the pandemic and how the bankruptcy systems there are able to shore up and deal with the problem. Last but not the least, we have George Felman, who we are very grateful for getting up very, very early in the morning. So a very good morning to you, Josh. Sorry for having dragged you out of bed so early, but we hope that you will be, as a person who's an economist who has had a watch on the global linkages between macro economies of various countries and the financial sector, particularly from the experiences that you've had in dealing with financial stress in the Far East Asian countries during the 1998 episode, and of course, as a born-again Indian, to tell us about your observations about how the Indian financial system and the macroeconomy are interlinked in periods of stress, and how it is that we are different from how you have seen the rest of the world deal with this, and what are your thoughts on the latest interventions that have happened or has taken place in India today. So because we're thinking about insolvency resolution, and we have understood and broken down the entire legal framework that enables people to deal with stress of financial firms into three blocks. That is, there are secured creditors who have their rights, and there's a legal framework typically about stressed asset resolution and provisioning norms that typically sit in the hand of the banking regulator. That's one part of it. And as Mukulita mentioned, there are other laws like SARFACI, which empower secured creditors different rights as compared with the rest of the world. The rest of the system. Because there has been India has dealt with, and sorry, to go back, there is secured creditor rights, which is about the banking system and how they deal with stressed assets. There is, of course, the collective action, which is what the IBC would have provided, except now it has been suspended. And there is the liquidation of firms that are actually not going to make it through this without much help at all. So if we think about these three pieces as the insolvency resolution piece, and if we think that the pandemic is a time when firms are going to be in stress, entrepreneurs are going to be facing exceptional stress. As Neeti mentioned, different countries have recognized this problem and put in place different solutions for dealing with it. India is, of course, as Mukulita pointed out, quite different in how we've put in place a stopgap. And there are good ways and there are bad ways of thinking about it. We've, for the secured creditor rights, we've put in place a moratorium where if there are repayments on debt that are supposed to be made in this period, they do not have to be made during this period. Banks and other kinds of creditors cannot collect. And on the collective action piece, the IBC has been suspended for, I think, about a year, although I'm not sure whether that hasn't been changed. So perhaps people on the panel can correct me if I'm wrong. So if these two are the big interventions that India has made, one of the curiosities that have come to mind is that as Mukulita mentioned, there's an entire ecosystem of various kinds of instruments and levers that can be used. These two pieces have been taken off the table. What is the rationale for saying that, irrespective of the fact that in a pandemic we are going to have financial stress, we would have thought that we need even more to have the IBC in place to help resolve insolvency. And India has chosen to suspend the ability to file for resolution under the IBC. Can I invite Dr. KP to, as a person who's been watching the policy process for the longest time, to come in with his views on what could be the rationale that defends this, wearing both your economist as well as your lawyer hat. Dr. KP, floor is yours.
Good afternoon. Am I audible?
Yes, you are.
Yeah, thank you. Let me start. Thank you, Susan. Let me start with a word of thanks to the City of London Corporation for organizing this very timely webinar. Let me also take this opportunity to wish friends from the UK and the US who are participating in the program my greetings to Madam Mukulita, fellow panelists, Neeti, Shikha, Bahramji, Susan. Susan, just a factual, quick one-line correction. I was not the chair, but I was the member secretary of the BLRC. The chair was Mr. P.K. Vishwanathan, who used to be our law secretary, and Mr. Vishwanathan used to be Mukulita's boss and a guru for a lot of us. He was the chair, and I currently chair the cross-border insolvency related rules and regulations committee. Let me straight away jump into the question that Susan posed, the rationale for introduction of a pause into what we've characterized as an economic process. Let me add that this is clearly not the formal view of the government of India, because I don't formally speak for the government. Clearly, I have a sense of what was the thinking behind these changes that have been made, based on conversations with colleagues who dealt with it, colleagues who are dealing with it. So this is my understanding of what is the motivation behind the changes. I think we should start with the basic premise of the IBC. Some of this was mentioned by Mr. Sahu, the chairperson of the Insolvency Bankruptcy Board of India, in a very good piece that he wrote, I think, in the Financial Express, where he pointed out that, remember, the basic premise of the IBC is value maximization to serve the economy and not just the creditors. I repeat, IBC was never intended as a debt recovery tool. So I think one should keep this broad background in mind. And like other jurisdictions, Madam Mukulita ji mentioned it, and Susan also did, and one of the panelists also spoke about the changes that have been done in India. The three important steps that India has taken recently: A, increase the threshold for initiating corporate insolvency resolution process from 100,000 rupees to rupees 10 million. So in our act, rupees 1 lakh, which was the threshold, has become rupees 1 crore. 100,000 rupees to 10 million rupees. So it's a substantial, an order of magnitude in the threshold for initiating CIRP. Second, a new section 10A has been inserted in the IBC, and essentially the effect of the section is no application for initiation of CIRP, corporate insolvency resolution process, of a corporate debtor shall ever be filed for any default arising on or after 25 March 2020 for a period of 6 months or such further period, but not exceeding 1 year. So an upper limit of 1 year starting with 25 March 2020, and no application for initiation of CIRP of a corporate debtor shall ever be filed. Step 3, the intention, and this is not yet done, the intention to notify a special mechanism for insolvency resolution of MSMEs under section 240A of the code. One small tidbit which may be of interesting sort of significance. Susan and Bahram, I think, will recall that the 2014 budget announcement was an insolvency bankruptcy process for MSMEs. That was the initial announcement. It was then felt that a separate process for MSMEs alone could open up questions on constitutional validity, etc. So we must have a general law, not merely for MSMEs. Ironically, we have now, after having crafted a general framework, we are trying to craft a sort of a special framework for MSMEs. This is yet to be notified. I believe all of the work has been done. The notification is expected soon. The last measure, perhaps not very major, is exclusion of the lockdown period for purposes of calculation of timeline for CIRP and liquidation. Let me now quickly, in the next couple of minutes, given the time limit, try and explain why were these done. My reading is, A, intent of the Government of India was stabilize the business ecosystem and bring banking operations on track instead of chasing borrowers for recovery, which in turn was felt would create problems for both the lender and the borrower. So A, stabilize the business ecosystem, bring banking operations back into sort of some kind of semblance of normalcy. Reason B, create a positive working environment for everybody and give each stakeholder enough time to recoup and recover. This bit is straight from the objects and reasons that preceded the ordinance and some of the press notes that were issued. The third one, which isn't explicitly mentioned, at least in the public documentation, but which was very much a part of the discussions, is reduce the load on the judicial infrastructure, which is clearly already clogged with a severe backlog of cases. And the fourth one, safeguard the working and viable businesses from being pushed into insolvency on account of the unforeseen, unprecedented situation created by COVID-19. Now, Susan, if I get one more minute, I'd just like to speculate on what I think were the thoughts underpinning these. One, clearly, government thinks, and this has again been articulated by the chairman of IBBI, some of these measures, especially the timeline related measure, will help insolvency professionals involved in ongoing CIRP to act in a manner to yield the best possible results and avoid untimely liquidation of corporate debtors on account of the lockdown and COVID related conditions. Number two, the increase in the threshold is likely to help medium and small industries, which clearly are hit the hardest of all the various sectors in the economy by COVID-19. But I think the implication that we need to watch is the ability of operational creditors to initiate CIRP since the minimum default amount is now a multiple of the previous minimum default amount. I think this has very significant implications. And I think once the economy stabilizes, the government would perhaps need to consider going back to some reduced limit. Can't guess what the limit would be, but I think we need to get back to a limit where operational creditors can continue to use the IBC in the event of default of their debts. I think I'm already way beyond my time. Perhaps I should stop here. And in case there is time and there is interest, there are questions, I'll come back to some of these points. Thank you.
Thanks a lot, Dr. KP. That was succinct and very useful to have as a background for the changes. Bahram, you're a person who is watching actual resolutions and as well as talking with the banks as creditors who have to deal with the problems of moratoria as well as old problems and new. Can you tell us something about the experiences that you have seen in terms of this new regime of moratoria plus suspension of the IBC, and how both the creditor ecosystem and the debtor ecosystem in India is responding to it? Thank you.
I think we've lost Bahram. He might be rejoining. Yeah, he's reconnecting.
Yeah.
Mr. Bahram, can you just see your microphone, whether it is mute or unmute?
Yeah, it's unmute. Sorry, I mean,
Okay.
it just logged me off. There was some.
Yes, we are able to listen now. We are able to listen now. Yeah.
Okay. Sincere apologies. I'll try and catch up quickly. So thank you so much. Apologies for that. Thank you to the City of London. Thank you so much, Susan, for all your kind words. And thank you, Dr. Krishnan, for the privilege of being on that terrific committee. With that, I'll quickly get to the question. So you've already got a fantastic summary of the ordinance, both from Mukulita ji and from Dr. Krishnan. So I won't delve on that at all. It's also very, very new. I mean, it's been just around 20 days since it's come into effect. So early days yet, but I think it will benefit the SMEs the most, which was the idea. Both, as Dr. Krishnan said, the hike to 1 crore and also the fact that they are the most vulnerable, as we have seen through this unfortunate crisis. So the idea was that they are the ones who require the protection. I would like to highlight, though, that this is a bit of a double-edged sword, and I hope we come back as fast as possible, because they also benefited greatly from IBC, which was one of the core intentions of the IBC, was that especially for the smaller operational creditors, their leverage was extremely low. As we used to always joke and say, they barely got their foot in the door. They were brushed aside by the receptionist. And as the stats will show, which of course IBBI has in great detail, vast majority of these cases are being settled prior to admission even, and a whole bunch during the CIRP process. And I'm quite sure if someone delves into these, maybe Susan already has, then you will see that a lot of these are the dues of the small operational creditors which are getting paid off, because of course nobody is going to risk their company for a small amount. So though the intention very clearly, as Dr. Krishnan said, is not a recovery mechanism, de facto there has been a terrific leverage for the operational creditors. So I think therefore that's a two-edged thing. In terms of what we have seen so far, I think what we've seen is that the NCLT, which is running on less than half steam, because just now it's just hearing emergency cases, but we have already seen in, say, Jet Airways, which many of you may feel is a waste of time just limping along. But what we have seen is some pretty bold orders from NCLT, and I'll give you just one instance, given the paucity of time, that usually you cannot pay one creditor out of turn. But as some of you may have read, they have a pretty lucrative piece of property in Bandra Kurla, and with a small payment to the bank which had the mortgage, HDFC, they could free up that land, sell the land, and of course there's a lot of interest even in today's market for that piece of land. And then from that sale proceeds, we explained to NCLT, and fortunately we were successful and we got a very good order, well-reasoned order, saying that with those proceeds, we could, with a tiny stub amount of about 10%, free up 8 leased aircraft. So, of course, the liquidation value, if that's what happens eventually, though there are still amazingly some bids on the table, the liquidation value will be greatly enhanced by 8 aircraft. And you just pay 10% of the value because you've already paid 90% prior. So these kind of innovative orders, with similar kind of thing happening in a case involving GMR. So that's what you have to do. As we mentioned also, that there are the DRT and SARFAESI issues can continue. So you can do that. And to be very clear, this is only if the default is post 25th March. If it is pre 25th March, then certainly you can go ahead and file. And as Dr. Krishnan said, the huge backlog hopefully will also get eased out, especially because the strength of the NCLT members was doubled. And we hope that that will happen with NCLAT as well. So given the paucity of time and the caliber of the panel, I think I would like to leave it there. Many thanks.
Thanks a lot, Bahram. It's an interesting feature of both the panelists so far that they have mentioned both a pro and a con of the interventions that India has taken in terms of the SME balance sheet. Exactly the entity that we were hoping to help in terms of rescuing from the pandemic. Now that we've had a look at the Indian system, both in terms of the rationale as well as a bit of the story of what's happening on the ground, can I now turn to Philip and Angela as the people who are watching a completely different ecosystem and a different jurisdiction? Angela, you've heard how it is that we have put in place a moratorium which basically acts as a barrier for the banking system or other creditors to try recovery during this pandemic. What is your sense of what the UK has done and how the creditors in the ecosystem there are responding to it? Because all of us have to agree the stress is real. The question is India doing the right thing in your view? How is the UK taking it forward, and how are the creditors responding?
Okay. Firstly, I'd just like to say thank you for the opportunity of being able to join the webinar and talk to you all today. The position in the UK has been an interesting one. I'm going to start with some figures. So when I I looked at the figures for the announced insolvencies from the beginning of the year. So for the first quarter, for January, February and March, there were a total of 3,883 corporate insolvencies, which was actually a drop of 8.5% on comparable figures. In April 2020, we had 1,196. That's only for 1 month, but I think that's a little drop there if you take an average for the first quarter. And then in May, we had 994. So we've got a drop again. We haven't got the figures available for June as yet, but the daily averages of corporate insolvency procedures have been dropping during the period, and that perhaps is not what you would expect to be happening, given the pandemic and the dramatic effects it's having on businesses globally. And I think the reasons for this are numerous. The first is simply too early for the effects of the pandemic to have flowed through the whole of the business community. Talking to other colleagues and insolvency practitioners within the UK, I think we expect the real effect of the pandemic here towards the end of the year, in terms of increased numbers of requests for assistance and advice and for filing procedures. So at the moment, we think a lot of businesses where they've had furloughed staff and they have been working in a much reduced mode are simply not, and also they have the benefits of a relief of the wrongful trading provisions, which Philip will address in his talk. I think a lot of businesses, simply put, haven't turned their minds to it and are just getting by to the extent that they can with the protections that the government has been promising, offering, and now will materialise in the Corporate Governance and Insolvency Bill. The government did announce at the start of the lockdown here at the end of March, last week of March, a number of measures that were aimed at assisting in the hardship that individuals, also, which is outside the scope of this presentation, individuals and corporates would be feeling, and also the Financial Conduct Authority issued a number of what are termed guidelines to their members, but really guidelines which the members have to follow, so they're not really optional. And the combined effect of those guidelines has made creditors think, and I'm speaking very generally, now is not the time to rush in with an enforcement procedure or an action against a defaulting customer, because simply put, it's not where you want the court's assistance or you need the court's assistance. It's not going to be viewed very kindly by the court where the impact, where the debt or the financial position of the customer has been generated solely by the effects of the pandemic. If there are other reasons that the customer is in default and has been in default for a while before COVID, then that's different. But simply because of COVID, a court is very unlikely at the moment to make any kind of discretionary order, which at the end of the day, an order for winding up and an order to place a company into administration they are both discretionary judgments for the court to make. What I have seen since the pandemic arrived here is I've had a number of requests from secured lenders to amend facility documents to waive or ease the effect of financial covenants where they simply would not be able to be met during the current circumstances. And that has been really in particular in the hotels, and leisure and retail sector, where a hotel, for example, might have a covenant to keep the number of rooms let at a certain percentage. And they just simply obviously aren't able to meet that covenant at the moment. And the banks have looked at those requests benignly and have accommodated them, because no secured lender really wants to have to enforce its security if there is any doubt that their security coverage isn't going to recover 100% of the outstandings under the facility agreement. So that's where I have seen the flexibility within the market, I suppose, in that lenders in particular and stakeholders and other stakeholders are waiting to see what will happen once we do emerge from the pandemic and life starts to return something like to normal. In addition to that, I think the situation has been ameliorated by the fact that the government announced a number of changes it was going to make at the start of lockdown, and to the legislation, and offered a certain amount of financial aid. So there are business loans available, small business loans, but business loans were made available to companies that fitted certain criteria to help them through the process, through the time of the pandemic. And they also introduced something called a bounce back loan, which is again a modest loan, but it will help companies get back on their feet once they are free to do so and the restrictions have been lifted. The market also took on board the changes that the government announced it would be implementing to various areas of insolvency. The relaxation of some of the directors' duties, being a main one, as I alluded to earlier, the sort of wrongful trading provisions, and the promise of new processes to help companies find a rescue solution should they still find themselves in a position after the pandemic where they can't trade as normal. So and those solutions are in the Corporate Governance and Insolvency Bill. It's been through 3 readings in the House of Commons and the House of Lords. Some amendments have been put forward. So we're nearly at the end of the legislative process. From a corporate point of view, the very interesting proposals are a new company moratorium, which will which will give companies breathing space for 20 business days initially, and that can be extended to 40 business days if needed, or longer. But if it's longer than 40 business days, the court will need to consent to that. And then there will be a monitor appointed who will be an insolvency practitioner to help the company through that period formulate some kind of rescue plan. And this is an interesting development, because we did have a moratorium previously in the legislation, and we still do, obviously, but that only applied to small companies, and so there weren't a huge number of companies in the jurisdiction that were able to take advantage of that. And there is a moratorium that comes with the administration process, but obviously to get the advantage of that, you have to have started administration. And it may be that administration was not appropriate for the business, or might not be appropriate for the business in question. So this is a welcome development in putting a freestanding, if you like, moratorium, while company directors look at how they can proceed. And then we have the new rescue tool, which is based on schemes of arrangement, which will allow a cram down across classes of creditors. So it's like the existing scheme of arrangement, but it allows a cram down. So in that way, it resembles more closely a sort of Chapter 11 of the United States Bankruptcy Code. And it's difficult to know at this stage, obviously, how much use companies will be making of these new procedures. I suspect the moratorium will be more heavily used, at least initially, than the rescue plan. But it's going to be towards the end of this year and the beginning of 2021. We're going to see the real effect of the pandemic, I think, and we're going to see the real benefit or not of the CGI bill as in assisting those that have been affected by the pandemic going forward.
Thanks a lot, Angela. So it's interesting that the kind of responses that you're talking about right now is more market responses, creditor-led responses as compared with any interventions, but there are features that are being proposed in the new bill, and they're presumed to kick in once the stress actually shows up, whereas our interventions have actually been put in place prior to any evidence of the stress as beforehand. So, Philip, can I now invite you to tell us if there is any if there's any evidence that you're seeing from the point of view of the things that the debtors themselves are doing with respect to the UK, or whatever else you think is pertinent for our discussion today. Thank you.
Thank you, Susan, and good afternoon, good morning, namaskar to everyone. Alderman Keaveney, Madam Vijaywargiya, Susan, lovely to see you again, esteemed panelists, and thank you to the City of London for organising this excellent talk. So in terms of debtors, I think it's partly driven by some of the policy decisions that have been made during this period of great threat and uncertainty. And I'd just like to share some of those with you. So Angela mentioned briefly suspension of wrongful trading. This is actually not actually happened yet. It's something that the government announced fairly early on after lockdown in April, and they said that they were going to suspend wrongful trading so that directors of companies where they were concerned that they might be seen as trading whilst insolvent couldn't be held personally liable for debts that had occurred due to their trading. This is something which is in the Corporate Insolvency and Governance Bill, which is currently before the House of Lords, and is to come in. But it's had the effect of saying, well, the government is doing something to provide support. In real effect, in real terms, in fact, there are other and bigger issues for directors. There's still possibility of personal liability for misfeasance or for fraudulent trading, and there is also, as you'll know, with the Companies Act being so similar, directors' duties under the Companies Act, if there is insolvency, the emphasis changes from members, shareholders, to creditors. And so directors are really taking advice. They're taking advice from insolvency practitioners where they are concerned about wrongful trading or trading whilst insolvent, and trying to document their decisions. They've been quite careful about paying back any loans that are, for instance, supported by personal guarantees, where the directors have given personal guarantees because they might be seen as preferential repayments, could be reviewable. They're also looking quite carefully, I think, where the government has brought out a slew of measures to support businesses by way of loans, both bounce back loans as well as the coronavirus business lending scheme, to take those loans if they are actually insolvent and not in a position to repay them. That's one thing in terms of directors' duties and wrongful trading. Secondly, on the 7th of May, the Cabinet Office of the government issued some guidance, and they issued guidance to contracting parties to say that you must try and abide and to maintain your contracts as far as possible, fairly and reasonably. So if you have a position where you could take insolvency action, or you could take action for breach of contract, try and keep the contract going if you can. They specifically mention including financial institutions. And so this is something which I think is if you were a debtor, you would be seeking to invoke. It's only guidance, so it's not binding, but you would be seeking to invoke that against the bank if the bank is saying you're in breach of your financial covenants, or you would be seeking to invoke it in relation to a counterparty, which is a government body. So it might be a local authority, it might be a government body, which is your counterparty, and you would be saying, look at the Cabinet Office guidance. This is government guidance. It's not binding, but really give me time. These are exceptional times. The third thing I'd say is that whilst there hasn't been a suspension per se of hearing winding up petitions, our insolvency courts for company insolvency said they would not hear petitions remotely. So because of COVID, where hearings can't be held in person, that has effectively acted as a buffer to say that even if you've presented a demand on a company and you're now able to present a petition, the courts are not going to hear it for a period of 3 months. So this is again something which is in the draft legislation, which is coming in probably at the end of this month, so next week possibly, and or very shortly thereafter. So effectively that has acted as a stay on corporate insolvency and gives some breathing space for companies. The fourth thing is that under the draft legislation, where you have a contract which provides for companies to be able to terminate supplies in the event of insolvency or a company entering into arrangement, that has been disallowed. So under the Insolvency Act, the new insolvency rules, and that means that suppliers may have to continue to supply an insolvent company, provided it is paying them, so as to try and enable it to trade out of that insolvent situation.
Thank you, Phil. That was actually thanks, Phil. That was actually quite interesting. So you're saying that all of these changes. So you have a bill, and I'm presuming that the bill itself was in process of being placed before Parliament, designing way before the pandemic hit. But that there are certain changes that have been introduced as a consequence of COVID. And when you said that judges said that they will not hear the petition on company insolvency applications for 3 months. That's not part of the bill, isn't it? I mean, or is it part of the bill? Is it going to be part of the law?
It is. Not that they wouldn't hear it remotely. That was a practical measure which had the effect of allowing leeway. But the bill does introduce effectively a stay on COVID-related company debts. So it introduces a but-for test. So if the question is but for COVID-19 and its financial effects, the company would have been solvent, you wouldn't be able to proceed with a winding up petition. That's actually to obtain a winding up of the company. The problem with this, which is in the draft legislation, is that often the damage is done when a petition is presented before it's heard and it's advertised. And so that does cause a problem, because by the time it's heard, you've debated whether or not it's COVID related and therefore should be allowed. At that stage, everyone has piled in, and the damage is probably irreversible. So that's part of the problem.
Okay, Vincent, can
Susan,
I invite?
Yes. And Philip, I think Philip has done a very good job and Angela indeed setting the scene. I just mentioned a couple of points. One point you've just picked up, which is that this bill has been introduced at very short notice. And it has gone through its parliamentary stages at great speed. In fact, it's likely to become an act before the end of this week. I'm sure that means there's probably lots of things in this bill that will only become apparent, and issues and problems in this bill that will only become apparent when it's implemented, of course, which will be grist to the mill for the lawyers and the insolvency practitioners on this call as they begin to work out where these issues arise. It falls into two parts. There's the COVID-related issues that Angela and Philip have been discussing. And there's also the couple of additional points that Angela mentioned in relation to the new powers of the moratorium and the restructuring plan. And this is actually quite a significant shift. It's something that insolvency practitioners have been talking about in the UK for a long time. The idea of a cross-class cram down on creditors, for instance, is something a lot of insolvency practitioners have been looking at for quite some time and moved closer to a Chapter 11 type regime. And with the pandemic has been the catalyst for what is a significant shift in the balance in the UK insolvency environment from creditor to debtor. And I think we're all going to just wait and see over the next year or two how these developments, which have been born in the heat of the pandemic, as they develop and emerge in the corporate life of the UK after the pandemic, where no doubt we're going to be dealing with long-term business effects from the pandemic. So we're at a fascinating point, an inflection point, no doubt, in the UK insolvency world.
Thank you. That's really useful. I was just going to say that, I mean, from after hearing Philip and Angela, my question was, who was it that drove the rationale for the bill? And I think that explains it wonderfully. So I'm tempted to ask tons of questions, but I'm aware of the shortness of time. And I know that Josh has been waiting very patiently. Josh, can I invite you to pull all of this together and tell us what are your views on dealing with pandemic and bankruptcy reforms for such times versus normal times, and what is your view on how India has tackled it? All yours.
Okay, people can see and hear me? Yes? Hello?
Yes, you can. You're on.
Okay. All right. Okay. So let me allow me to give you some perspective as an economist. Obviously, pandemic has been an extremely severe shock. That's true in India. It's true in virtually every country. India is a bit different, though, in several respects that we really need to keep in mind. One is that even before the pandemic, profits of the corporate sector were extremely low. In fact, they were at historic lows relative to GDP. In other words, even before the pandemic, the corporate sector was in bad shape. The other thing that is important to keep in mind is that the banking sector in India was in extremely bad shape before the crisis, with non-performing assets around 10% of loans at the public sector banks. So that means that the India corporate and banking sectors were in a very, very poor position to withstand this shock. The other factor that is also very, very important to keep in mind, and that kind of relates to the ones that I mentioned before, is that India has had extreme difficulty with cleaning up when companies get under stress. It's been 10 years since the global financial crisis, and still, as I just mentioned, the corporate sector, the banking sector, really not been restored to health, notwithstanding the IBC. So if you have a situation where the shock is very severe, the ability to withstand the shock is very poor, and the ability to clean up after the shock is very poor, then you're in a very difficult situation indeed. So what do you need to do? Clearly, you need to do as much as you can to prevent bankruptcies. And the way to do that is to make loans to tide over the viable companies. So the government has issued a loan guarantee program, a very large one, for 3 trillion rupees. But it's badly designed, and essentially because it gives 100% guarantee, which means that the guarantees are probably unlikely to go to the viable companies, much more likely to go to the unviable ones whose loans will effectively be passed on to the government. The other thing, of course, is the government has announced the moratoria, which people have discussed. But the problem is the moratoria doesn't solve the problem; it just delays dealing with the problem. So we still need to find ultimately some solution to the problem, some way of giving debt relief for the economically viable but financially unviable companies. And we need to do this as quickly as possible so that the economy can get back on its feet as quickly as possible. And one thing that we also need to keep in mind is that it's actually the debtors who need help. Ideally, many of the debtors who have got into trouble solely because of the pandemic need to have their debts reduced to a viable level, and then they can just move on, and the economy can just move on. So how do you do that? Well, some mention was made earlier that maybe informal mechanisms will work. But informal mechanisms do not work in India. As I've just explained, even with a variety of formal mechanisms preceding the IBC, including the IBC, India's had huge problems dealing with stressed assets. So you need some sort of procedure to deal with the problem. In an article in the Indian Express, I proposed such a procedure with the former chief economic advisor of India, Vincent. And I'd just like to take 1 minute to sketch it out. So, like in the UK, I proposed in the article a but-for test. The first thing that would happen is that the creditors would decide whether an enterprise is a CAE, a COVID-affected enterprise, or whether its problems predated the crisis. If it's determined that it's a CAE, then special procedures are invoked. Now, importantly, these will be special procedures under the IBC. So effectively, the IBC would hold, but certain provisions would be suspended. In particular, the provisions that would be suspended are that there would be, the IBC is essentially an auction. Once an enterprise enters into the IBC, it's then auctioned off, and importantly, the existing owners cannot bid for the enterprise. Both those provisions would be suspended. What would happen is that there would be no auction of the enterprise. If it's a COVID-affected enterprise, there would be no auction of the enterprise. And in fact, the original owners would be expected to retain the enterprise. And the only discussion would be how much debt relief does this enterprise get? And that would be determined in the usual IBC way, but under some simplified procedures where an insolvency professional studies the situation, makes an assessment, and then the creditors vote on the proposals. The advantage of this is that first, it does not penalize the entrepreneurs and the owners for problems not of their own creation. Second, it's simplified and therefore speedier. And in the article, we call this the simplified non-adversarial procedures, or special non-adversarial procedures rather, SNAP. And as I mentioned, all the details of this are set out in 2 Indian Express articles. Thank you.
Thanks a lot, Josh. That is food for thought indeed. While I agree with you that we have had a very poor track record in terms of putting in place any kind of resolution, I worry that that credibility of ours of putting in place very poor informal systems and solutions in place will continue. And of course, we can debate about whether some of these things make sense. Like, for instance, your the comment that the 29A, which is that existing entrepreneurs cannot bid, should be removed for these COVID-affected enterprises, makes eminent sense. And this is a cool idea, and I think some of these will work. But as long as we don't have a full market of creditors who can take these decisions to determine which are COVID affected versus not, maybe even there a simple test can be designed. This is still going to be a question in terms of opening up to quick resolutions. But thank you very much for those thoughts, and I thank all the panelists. I'd like to not take any more time, but I would like to invite Neeti to be the first person to ask a question. I forgot to tell people that as we hear our speakers on the panel, please do feel free to put up questions, and I know that some of you have. I will pass through those questions and ask them as we go along. But Neeti, do you have any questions to start off this Q&A session?
Yeah, thanks, Susan. In fact, I did have one question, and I'm happy to see that one of the somebody in the audience also has asked same question. I wanted to know. I mean, this question is open to Mr. Krishnan or Ms. Mukulita or you. Suspension of Section 10 has it sort of forces the companies to go into further stress. Why are corporate debtors not given a option to file for insolvency even if they wish to? Don't you think that suspension of their right to file for insolvency would rather push the companies into further debt and rather minimize the value of assets over time?
So can I invite either Mukulita or Mukulita, would you like to take a shot at this, and perhaps then we can request Dr. KP to give his response to this question. Why are debtors not allowed to file? Because say for instance in Josh's idea, that's central, that it should be the debtor of a COVID affected enterprise that should have the ability to protect the enterprise by going through IBC in a structured manner, with perhaps some of these provisions unlocked. Is that not a more viable way of dealing with the COVID pandemic as compared with not allowing anyone to file? Mukulita, would you like to take a shot at this? Dr. Krishnan?
Yeah, Susan, I can guess. I sort of don't know what is the formal official reason behind this, but my guess is it could potentially be a very large number. Even if you're just talking about the debtors being allowed to use the existing process, my reading of the situation is the existing backlog, the ability of the judicial infrastructure to be able to handle it, etc., would have been the consideration why this wasn't permitted. Should it be permitted? My personal view is yes, I think it ought to be, but clearly the judicial infrastructure is already, I think, bursting at the seams, and I think it's useful to know is, like the question that was asked during the lockdown, are we using the lockdown to prepare for the post-lockdown period? I think the more important question is, are we using this quote-unquote cooling off period to get ready for what could sort of emerge post the situation? I think the answer is certainly partly yes, because there is a decision already of the cabinet hugely increasing the number of benches of NCLT as well as NCLAT. So I think in terms of numbers of judges, numbers of benches, there is clearly an attempt being made. So my answer would be probably the likely explosion in the case, in the number of cases, and the government's presumption that the current machinery doesn't have the ability to handle it. That would be my guess.
Thank you very much. I guess then that Josh's solution of saying that it should be applicable only to a select set of firms where the creditors have certified that they are viable firms but for the COVID pandemic is probably something that we should think a little more deeply about and figure out how to put in place. I have a second question, which is from Anuradha. Anuradha, would you like to ask the question, and please, who would you like to answer this question? I think that if I read through your question, this is about individual insolvencies as opposed to corporate insolvency. Perhaps Philip or Vincent or Angela, is there a sense that you are that you can offer us on the question that Anuradha has, which is that how do you deal with individual insolvencies during pandemics? Vincent?
Well, yes, I could. I can come in on that just to say, well, and I think Angela mentioned that the banks have been in a very benign position. Creditors generally have been taking a very benign approach on corporate insolvencies, and that's reflected as well in relation to individual financial obligations too. So there has been a series of payment holidays, which the FCA and other regulatory bodies have effectively required banks and finance companies to provide to their customers, and that I think that has permeated through the entire financial system. There is no great desire to see an uptick in insolvency processes at the moment for the various policy reasons that people have been discussing. And I think the other point, and Philip touched on this as well, the courts themselves haven't been in a position to deal with insolvency applications on the same basis that they would have been normally. I don't know, Philip or Angela, whether you want to add to that.
I think that's right. I don't know if you can hear me, but that's
yes,
right.
Philip, we can hear you.
I mean, we have seen because the focus has been on trying to protect companies. Some people have issued demands and are pursuing individual insolvency, particularly where there are personal guarantees, for instance. So that part of it is still ongoing and is being pursued. But there are the period. That's one of the rules that has changed. Is the normal period to respond to a statutory demand on personal insolvency is a period of 18 days, and that has been extended the maximum permissible to 56 days between the parties. So it's 21 days, 8 days to pay. It's been extended to 56 days, which is again exceptional, and we are seeing that people are taking a more lenient view in certain cases.
Thanks a lot, Philip. That was interesting, and I think that does answer parts of Anuradha's question. I know that there are other questions. This is always what happens when you put together a bunch of people who love thinking about bankruptcy and insolvency reforms, but I'm conscious of being out of time. It is now 4:30, and what I will do is I will look to Anita and Neeti, because we do have a plan of continuing these going forward. We will. One of the things that we can do is to take all of your questions and then try to collate some answers and get back to you with the answers. But right now, I'm going to hand the floor over to Anita and Neeti to tell us how to wind this very interesting session down and what we can look to going forward. Thank you. Thank you.
Yeah, Anita, would you like to give some closing remarks before I put the question for the poll?
Thanks very much. And thank you, everyone. Thank you so much to all the panelists for taking time. What we will do is, obviously, we have received a number of questions, so we will be documenting that. And hopefully, what we're planning to do is come up with a policy note at the end of it, so which we will collate the questions and also some of the responses from the panelists, and then circulate it to everyone who joined the session today. And of course, going forward, as I think Neeti mentioned, is that this is just the first of our sessions, and what we'll definitely do are several other discussions of a similar nature where we can get the experts to speak on. And obviously, I think the critical thing is how do we ensure that we exchange learnings and best practices, and that's the whole objective of doing these series. Again, I think the poll is up. I think from my end, I just want to take this opportunity to thank everyone. Neeti, over to you.
Yeah, thank you so much, everyone, for joining, and especially the audience. I think we had a very engaging audience. The questions which has not been answered, we'll make sure that it is covered in our notes that we circulate with you shortly. And we will be documenting all the discussions and also reaching out to the panelists with the questions that remains unanswered, and then circulate to all the audience who have attended. There's a poll that you see on your screen. We would like to know what would you like the next session to be on. Please do cast in your votes here. That helps us to understand your interest and accordingly, plan the next webinar. And thank you, Susan. I think you've been the force behind today's webinar and for bringing us all together on this forum. And stay tuned to this GIP web handles on LinkedIn and on other social media, Twitter handles, and we will be in touch with all the viewers with the next session details. Yeah, thank you.
Thanks a lot.
Thank you.
Yeah.
Thank you all very much.
And special thanks to my IT team and Urvashi from the center who has helped us, and Shraddha from the City of London office who helped organizing this whole event. Thank you so much. And our special guest from London, thank you so much for joining.
Thank you.
Not at all. Thank you. It's been a real pleasure. Thanks, everybody. Have a good day and a good evening.
Thank you. Thank you very much. Thank you.
Yeah. Thanks, Bahram. Thanks.
Thanks, Bahram. Thanks a lot, Josh.
Thanks,
Dr. Krishnan.
Thanks all.
Thanks, Philip.
Good to see you all.
Hopefully, hopefully Angela's experience will be better the next time.
Yes.
We definitely work on that, Susan.
No,
Thanks,
that's fine.
Angela.
Take care. Stay safe.
Thank you. Let's keep in touch. Bye.
Yeah. Bye.
Bye.
Thanks. Bye.